Yeah, and one thing I mentioned is the issue of previous mistaken violations. And what one situation where we see this come up is with previous non-immigrant visa applications. So, Anya and I were talking before the show about a client who had mistakenly put a lot of bad information in their ESTA application. ESTA is a special non-visa, it's not a visa, it's a visa waiver. So that if you're from countries, you don't need to do an embassy interview to get a tourist visa. You could just go online, fill out a form, get that approved, and fly into the United States. But has 7 or 8 questions that are key. If you answer those incorrectly, it leads to you being denied. And if you're not denied and you use it, that could be considered misrepresentation or fraud. And it's the same thing with DS-160s. Could you talk about what the DS-160s, what's in it, and what the traps are that people get caught in that become consequential later, Anya?
Right. So DS-160 or 260. 160 is application for non-immigrant visa, right? And DS-260 is an application for immigrant visa, depending on which way you go, right?
Mm-hmm.
They're a bit different, but there are all kinds of questions there, including previous military service. That's what we see. That people who served in their home countries, who did their mandatory military service, they answer no to this kind of questions. And in fact, when they have to answer yes, right?
Yeah.
Sometimes someone helps them to fill these forms out, and the provider just don't ask them this question, and they just put this information from what they know. Or people mistakenly put this information there, or some people, they don't read the questions, they just want to make everything fast and
Yeah.
just submit it and forget about it, because we understand it's hard to deal with a lot of paperwork. Yes. And it's military service, as I mentioned. It's, for example, previous immigration law violations, right? For example, a person can come to the United States during COVID. This happened a lot, right? So a person comes to the United States, gets I-94 valid for 6 months. Usually it's 6 months for the tourist visa, right? And COVID hits and they overstay this time period allotted to them by the CBP officer, and they don't file for the extension because, again, not all people think that this is necessary. This is necessary. Not all people think that this is required. A lot of people thought that because of COVID, they're gonna forgive everybody, but this is not the case. The law has not changed, and it stays where it is. And person has violations, so person overstayed his previous. For example, during his previous visit to the United States, and now applies for another visa, or, for example, for immigrant visa, or want a green card. Anything can happen, right?
Yeah.
And people just don't realize that you have to answer yes to this question, because they don't even know that they violated something.
Yeah.
And again, that's where immigration attorney can help you with that.
Yeah, America's really strict on this stuff, and one of our jobs is it sounds simple, but really to push people is spend the attorney time of having a consultation, talking with them, and saying, "Have you been arrested?" Because as Anya, I've seen cases, sometimes you got to ask people multiple times to get that answer, and they don't remember or they don't want to say. But we say, "For sure, have you done this? Have you overstayed?" And we go step by step. We have to go through them because the military service. I've seen a lot of people forget to mention that they had mandatory military service. They thought it wasn't a big deal. Well, it is, because by not saying it, America's afraid. They're saying you're a person that has weapons training. You may have been in a country that might be, hostile to the United States, and we're just going to let you in. Obviously, this is a national security issue, which they take very seriously. There's people who don't mention previous marriages. That looks bad. People don't mention having children on the application. And then later on, they get their green card and they want to file for their children. They'll be like, "Well, you didn't previously tell us about these children." Now, some people watching will be like, "Who would do that?" But it happens all the time. And primarily, as you said, it's because they either don't read English or they have someone else fill it out who doesn't ask questions, or they're just in a rush to do it because they think it's not important. Because many times these forms in other countries are not important. But in America, they're really hardcore in the United States on immigration policy, and they look at all these kind of things and they will hold it against you later on. So really properly completed DS-160. If you're doing the ESTA application, make sure to do it right. It's so key, because what happens is you hit with misrepresentation, you're going to have a ban. You have to get a waiver. Not everyone can get a waiver. And so essentially, you'll never be able to come to the United States. And that's done in many cases. And imagine if you're married or your family's here, it's a disaster.
Yeah, I just want to mention that a lot of people, they think that, for example, if they answer, first thing, you have to always honestly answer these questions, right? The first thing is like rule of thumb, right?
Yeah.
And some people think that if they answer this question honestly, they might not get a visa. This is not necessarily the case. And a lot of visa agencies, that's what they do too. They just don't get this information from their clients. They fill in the forms just to get visas for their clients. They did their job and that's it. They forget about you. They don't care. What's going to happen later on in your immigration path, right? If you want to immigrate to the United States 5 years later after you applied for this tourist visa with all this misleading information. And it can really hurt your case very, very bad. And as John mentioned, there might be waiver required, might not be a waiver required, and it takes more time, more money, more efforts. Families get separated because of that. Yes, and another thing I wanted to mention is for situations like that, it's always good to file FOIA, Freedom of Information Act request. We talked about this, but probably in the previous episode. Where you can get all your information that U.S. government has on you, specifically U.S. Immigration Services. But again, it can take time. And for example, there are some deadlines for filing certain applications, and it's not always feasible to get this FOIA result before getting the case out, right? So again, just suggestion, please, if you file for a tourist visa, for F visa, for any kind of visa to the United States, please always save your DS form somewhere on your computer, or you can send it to yourself on your email, or just print it. Have it somewhere saved.
They made it really difficult to say the DS-160. For example, the DS-260 for green card immigrant visa, you could save a final copy as a PDF. For the DS-160, once it's submitted, you can't access it anymore, which is really annoying. So when you're doing your final review, I just save each page on my computer almost as a screenshot, because they don't make it easy. And it's really bad, because later on clients come to me, and for example, the L1 that we talked about, the L1, in their tourist visa application, they don't mention previous employment because the travel agent filled it out and didn't bother asking. And then the L1 is a case where you're working overseas for a company and they're transferring you to a U.S. branch. And then so we're here. I don't have a copy of the DS-160. Client tells me they did everything properly, and there's nothing from, it'll take forever for me to get a FOIA potentially to get the results. So we file the case and say, okay, they worked overseas, they're working here. And then USCIS comes back and says, well, in the tourist visa application, you mentioned you were not working, or you say you're working for somewhere else. So there's some fraud going on either at the L1 stage or at that previous one. Either way, you're denied, and we accuse you of fraud. So not only do they have to leave the U.S., they could never come back potentially. So it's so key to do this. And there's different kinds of FOIAs. There's a Department of State FOIA, which is harder to get, and they'll probably send a minimal amount of information. There's CBP FOIA from when you're entering the airport customs. Those are really hard to get to. They don't always comply, and they redact a lot of stuff. The best one is USCIS. They're good, but they still redact stuff. And then if you had immigration court, there's the EOIR FOIA, which comes relatively fast, I've seen. But it's important to do all possible. If there's a hint of issues with the case, and we don't necessarily do it with every case because there's more cost, and most cases that we deal with don't need it because everything's clean. But if you suspect something with the client or you have the time, it's good to just do it to make sure you did it right, so you know beforehand, especially if you're going to do citizenship, naturalization, for example. People come to naturalization and ask them a question, and as soon as I ask them, they're not positive about something, like, okay, we got to wait, we got to do FOIA, because if we come and file a citizenship application now and there are errors before, that citizenship application could trigger investigations and removal of the United States. Can you take your green card taken away, go to immigration court? So sometimes it's best not to touch it, but I don't want to move this forward. And clients are always in a rush. They want to get their citizenship. They rush, but I say, slow down. We got to do it right or not do it at all. Unfortunately, we see this all the time with these kind of issues pop up. That's why we're talking about this like literally every day. These issues we talk about on this show are things we see actively every day. And there's like Facebook groups, there's things online where you read and people say, oh, it's easy, it's just filling out a form. I wish it was that easy because, I care for my clients. I don't want them to pay a bunch of money and get, all this time. I wish it was just forms, but it's just not that easy. We see these disasters every single day at our firm when they come in.
Unfortunately, yes. And attorneys sometimes do mistakes too.
Yeah.
And we had this case where the form It was adjustment of status form was not properly filed by the attorney, and the attorney didn't answer the questions. Previous attorney didn't answer the questions the way it's supposed to be answered, and yes, it's a huge mess. And sometimes we can fix it. Sometimes it's not fixable at all. Yeah, and another thing I wanted to mention about this form is criminal history too. Again, a lot of people think that if they have criminal history, they will be denied entry to the United States. It depends. The answer, my favorite answer, it depends. It depends on what kind of conviction you have, when the crime was committed, right? If it's committed before you turn 18 or after, there's so many things about it, right?
Yeah.
But it's always, you have to answer the questions truthfully and just deal with the consequences.
And if you feel like it's a problem, especially for criminal history, talk with the lawyer, because you got to get all the police records, conviction records, court records, and the lawyer then has to read the statute, the laws as written, compare it with the inadmissibility statute, Immigration Naturalization Act, or INA 212 section, or 1182 at USC 82, and then see whether it falls within exception. If you could argue it's like this, if sometimes the statute's badly written, sometimes it's pled down to a lower offense. There's things where, like, if you only got less than like a year or 365 days, you got, let's say, 364-day conviction, it's different than a 365-day conviction. There's a million and one nuances that makes it complicated. So if it goes in that direction, you got to be mindful of it. And you mentioned the other attorney's work. We do a great job here. We have good reviews, all this kind of stuff. But it is important for a client to take charge of their own case and review their own documents. I don't mind clients asking us questions and reviewing the form and saying, why did you say this? Why did you say this? It's better we catch it before it's a problem than after it becomes a problem. So you have to take charge. You have to read your form. Don't just sign it, assuming your attorney did the right thing. You have to go through it together and spend that time. It's time consuming. That's why it costs money. Because it spends a lot of times, hours and hours of just reviewing, asking the same questions over again, make sure it's there. But that's what you got to do, hopefully, and just get it done one time instead of having issues down the line.
Yeah, and you cannot blame your attorney for later on for something that, for example, you didn't read. If you put your signature, so never put your signature on something that you have not read, that you don't understand. What is this about? If you need translation, you can ask for translation, right, or interpreter to do this for you. Yeah, because it's your signature, and by signing it, you like swear to the contents.
Yeah,
application or petition.
Most immigration judges will say, well, you signed it. And even there are rare cases where the lawyer's mistakes were so bad that it's bad. But if you sign the forms, you means you had the opportunity to read it and correct it. So they're going to hold you to it. So even if you complain about your lawyer and stuff, it's not going to go anywhere. Even the bar might say, well, you signed it. And unless you have, proof that the lawyer like just told you a lie or something, even then, at the end of the day, it is your responsibility. We're just here as guides. And, ideally lawyers won't lie or anything like that. They just, work with you, try to do the best they could do if needed, have the mindset of saying, okay, you have an issue here. We have to file for a waiver beforehand or with it or later, and just let them know what's up. There's no hiding this kind of stuff because the United States does massive information sharing with all governments in the world. Sometimes the computers are slow. It takes them a while to pick it up. We had a case recently where the person shouldn't have gotten a visa. They said no to the criminal history. And it took a while for U.S. government to catch up and put the dots together that this person should have got it. But they're going to get it, and we know they're getting it because there are certain other applications now are pending way too long. But it's going to come up.